What if I told you that the most dangerous moment in your entrepreneurial journey is not the moment your business fails? It is the moment you open your mouth in a pitch meeting and share everything without protecting anything. Consider this scenario. A Nigerian entrepreneur spent 18 months building a concept, a fintech solution targeting a gap in the market that nobody else had addressed, or addressed it in the way that she's about to. She had the research, the wireframes, the go-to market strategy. She even had early traction, a small but growing user base. She got a meeting with a well-connected potential partner, someone with distribution, capital, and industry relationships. She walked into that meeting and gave them everything: the product roadmap, the pricing model, the technology architecture. She left nothing out because she wanted them to see the full vision. They told her they would think about it. A few weeks passed, then a few months. She followed up. The responses became vague. 8 months later, she saw a press release. The same potential partner had launched a product almost identical to hers. Different name, similar architecture, same target market. She had no non-disclosure agreement, no confidentiality agreement, no record of what she had shared or when, just the memory of a pitch meeting and nothing in writing. That scenario, though hypothetical, is not strange in the Nigerian business landscape. It happens, and in almost every case, the founder walks away with nothing, not because the law cannot help them, but because they gave away everything before the law had anything to protect. Before I give you the tools, I want to give you the honest foundation, because many entrepreneurs come into this conversation with a misunderstanding. Under Nigerian law and under most legal systems globally, an idea by itself is not protected. Only the creative expression of that idea is protected. Copyright protects original creative expression of artistic works. Patents protect inventions, processes, products, technical solutions. Trademark protects brand identifiers. But a business concept, a market insight, a go-to market strategy, those things standing alone do not attract automatic legal protection. What the law protects is not the idea in your head. It is the documented expression of that idea and the obligations you create around sharing it. This means that the protection you have in a pitch meeting is almost entirely determined by what you did before you walked into the room, not what you said inside it. So what can you actually protect and how? Here are 4 tools available to you under Nigerian law. Tool 1, the non-disclosure agreement. A non-disclosure agreement, commonly called an NDA, is a contract. It creates a legal obligation on the other party to keep what you share confidential and not to use it for purposes beyond what you have agreed. Before you pitch to any investor, partner, or potential collaborator, send them an NDA and ask them to sign it before the meeting. Will everyone sign? No. Some investors refuse NDAs at early stages, arguing that they see too many pitches to commit to confidentiality on all of them. That refusal tells you something. Use it to calibrate how much you are going to share. And a solid NDA should cover a clear definition of what is confidential, the purpose for which the information can be used, the duration of the obligation, what happens if the obligation is breached. A poorly drafted NDA is almost as dangerous as no NDA at all. To be safe, get a lawyer to draft it or review it for you. Tool 2, the doctrine of breach of confidence. Even without a signed NDA, Nigerian law, drawing from English common law, recognizes a doctrine called breach of confidence. This means that where information is shared in circumstances that clearly import confidentiality, the recipient may legally be obligated to keep it confidential, even without a written agreement. For this doctrine to apply, 3 things must be shown. 1, that the information had the quality of confidence, that is, that it was not publicly available. 2, that it was shared in circumstances importing an obligation of confidence. And 3, that the recipient used it in an unauthorized way to the detriment of the person who shared it. This doctrine has been recognized in Nigerian courts, but it is significantly harder to prove than a written NDA. Use it as backup, not as your primary strategy. Tool 3. Copyright protection for your materials. Under the Copyright Act of 2022, original literary works are automatically protected from the moment of creation, even without registration. Your pitch deck, your business plan, your financial model, your product documentation, all of these are original literary works. They are protected by copyright the moment you create them. What this means in practice: someone who takes your pitch deck and reproduces it or uses your documented strategy word for word may be infringing on your copyright. What it does not mean: copyright does not protect the idea behind the document. It protects the document itself, the specific expression of the idea. If someone takes your concept and expresses it differently, copyright alone may not protect you. Document your creation dates. Email documents to yourself. Use version control. Keep drafts. In a copyright dispute, the person who can prove they created something first wins. Tool number 4. Patents for genuine inventions. If your business idea involves a technical invention, a new process, a new product, a new technical solution, you may be able to protect it with a patent. In Nigeria, patents are registered at the Federal Ministry of Industry, Trade and Investment under the Patents and Designs Act. A patent gives you the exclusive right to use, manufacture, or license your invention for 20 years from the filing date. The critical point: file before you pitch. Once you publicly disclose an invention, even in a pitch meeting, you may compromise your ability to patent it. An IP expert can advise you on whether your invention qualifies and how to file before you begin pitching. Beyond the legal tools, there are practical habits that every Nigerian entrepreneur should build into their pitching process. Before the pitch, send an NDA before sharing any materials, not during the meeting, before it. Document everything you have created and when. Drafts, wireframes, research models. Know what you are sharing and what you are not. Decide in advance what stays in the room. Register your trademark if you have a brand name before you pitch publicly. File a patent application if your idea involves a technical invention before disclosure. During the pitch, share enough to demonstrate the concept, not everything needed to replicate it. Do not share your full technical architecture with anyone who has not signed an NDA. If asked questions that go deeper than what you are comfortable with, note them and follow up after the NDA is in place. Bring a witness or record the meeting where legally and ethically permissible. After the pitch, send a follow-up email summarizing what was discussed. This helps you create a detailed record. Note exactly what you shared and with whom. If they pass on the investment, follow up to confirm in writing that your materials will be returned or destroyed. If you see your idea emerge elsewhere, consult a lawyer immediately before the trail goes cold. If the scenario I spoke about in the beginning has already happened to you, first, do not panic and do not post about it online. The moment you make public accusations, you change the legal landscape in ways that may not serve you. Here's what to do. Gather every piece of evidence you have: emails, pitch decks sent, WhatsApp messages, meeting notes. Document the similarities between what you shared and what was later launched. Check whether you signed any NDA or confidentiality agreement, even informally. Consult an IP lawyer immediately. Time is critical in these situations. Your legal options may include a claim for breach of confidence, even without a signed NDA, if the circumstances imported confidentiality. A copyright infringement claim, if your documented materials were directly reproduced. A civil claim for damages, you can demonstrate the loss you suffered. These cases are not easy. They require strong, credible evidence, but they are not impossible to prove. And the strength of your position depends almost entirely on how much you documented before the pitch. This is why protection must happen before the room, not after it. Before you leave, here's what you should do if you have a pitch coming up. Get an NDA drafted before that meeting, not a template you found online. A properly drafted NDA that covers your specific situation. The cost of that document is a fraction of what you stand to lose without it. And before you pitch anything anywhere, document what you have created and when. Emails, drafts, version histories, timestamps. Those records are your evidence if you ever need them. Your idea is valuable. Treat it like the asset that it is. Protect it before you share it. Because once it is in the room, it is very hard to put it back. If this video changed how you will prepare for your next pitch deck, subscribe to Goga's Brief. I am Goga, and I'll see you in the next one.